All right, good afternoon, everyone, and welcome to Wetlands on Trial, a lunch hour deep dive. I'm your host, Rachel Thompson, Executive Director of the Glynn Environmental Coalition. Today, we're going to share the history of our case, Glynn Environmental Coalition versus Sea Island Acquisition. To get us started, I do want to introduce the plaintiffs of the case. Founded in 1990, the Glynn Environmental Coalition works diligently to assure a clean environment and healthy economy for citizens of coastal Georgia. Glynn Environmental Coalition serves the community through education and outreach, community organizing, preparing technical assistance reports, comment submission, and requesting public hearings. The Center for a Sustainable Coast was established in 1997 to advance the application of science in protecting coastal Georgia's environment and quality of life. Jane Frazier is a local coastal Georgia resident and is a member of both environmental organizations. Now I'd like to introduce our attorneys who will unpack the case in plain language, explore what's at risk, and discuss how these decisions impact water quality, wildlife, and our community. Laura Husel and John Bernini are partners with the Butler Snow law firm. Laura focuses her practice on environmental diligence, environmental permitting and regulatory issues, and environmental litigation. John focuses almost exclusively on environmental, energy, and natural resources law. He has been recognized by Chambers USA as America's leading lawyers for business for his work in environmental law and by Super Lawyers as a Mid-South rising star.
Thanks, Rachel. And good afternoon to everyone, or good morning, depending on where you are. I'm John Bernini. I'm joined by Laura Heisel, and we're here to talk about the Glynn Environmental Coalition versus Sea Island Acquisition case. So we're going to cover a little bit of background on the alleged Clean Water Act violations. We'll discuss the full scope of the case, which started quite some time ago. We'll discuss some initial rulings at trial that led to an appeal, and then back to trial court, then another appeal, and finally a Supreme Court decision on our petition for certiorari. We'll discuss what we think the case means from a big picture standpoint for wetlands protection and Clean Water Act jurisprudence. And we'll talk about some reflections, some thoughts hopefully from Rachel and from others, maybe Ben and others, of what this case means to their membership and what it means for their ongoing efforts to protect wetlands in their area.
And some quick updates on the U.S. government's change of regulations governing wetlands and defining what is a jurisdictional water of the U.S. and some other cases that are also pending in the courts.
This is the purpose of this slide is intended to sort of represent the amount of time that it took for this case to travel its way up to the Supreme Court. The timeline shows that the underlying facts of the case started back in 2013 with an application by the Sea Island Acquisition entity for a Clean Water Act permit. Again, that was the 2013 to 14 time point. In 2019, after having sent a notice letter to the defendants, the environmental groups and Ms. Frazier filed a Clean Water Act citizen suit. In 2022, the district court dismissed that case based on some standing issues that we'll discuss. In 2023, the 11th Circuit overturned the dismissal and remanded the case back to trial. Later in 2023, the Sackett opinion was issued by the Supreme Court. And then in 2024, the district court dismissed the plaintiffs again, holding that the wetland was no longer jurisdictional after the Sackett ruling. 2025, the 11th Circuit affirmed trial court's decision in the case, and in 2026, the Supreme Court denied the petition for certiorari that we had filed. And so that was just back in March of 2026 that decision came down. In starting this case, or in starting to describe the case, it's probably important to give a a little bit of background on where we are in the statute and what was alleged. This Clean Water Act contains a citizenship provision, obviously, and suits may be filed against any person alleged to be in violation of an effluent standard or limitation. We've got a citation there. In this case, our plaintiffs alleged that Sea Island Acquisition obtained a Clean Water Act permit, a nationwide permit, to discharge fill material into coastal wetlands. It was also alleged that water from those wetlands flowed into an adjacent salt marsh, which would have clearly been jurisdictional waters, and then into Dunbar Creek. We alleged that Sea Island violated the Clean Water Act permit when it told the Corps that it planned to fill the wetland to construct a commercial building pursuant to the terms of Nationwide Permit 39. Just after filing that nationwide permit, as a factual matter, it was clear that Sea Island had submitted documentation to Glynn County showing a plan not to construct a building, but rather to perform some landscaping on the site. Ultimately, the wetland at issue was filled with sodding and landscaping activities took place on the site. No building was constructed then, and there's still no building on the site to date. So it's probably helpful at this point to describe, and this audience probably is familiar with it, but the difference between nationwide permits and individual permits. A nationwide permit is pre-approved, sort of a pre-approved category of activity that an applicant can seek a faster permit and can get that permit without public notice and without public participation. They're used for minor impacts for up to designated threshold quantities of stream or wetland impacts. And usually those quantities are very limited in nature. For individual permits, on the other hand, they require project-specific review. They require public notice and comment. They require, a substantial alternatives analysis and a demonstration of avoidance, minimization, and mitigation, and just in general, longer permitting and approval times for that process. And we've got a little note here at the bottom of the slide. There's constructing a commercial office building is something that's for which a nationwide permit exists. Nationwide Permit 39 allows that type of activity for up to half an acre of wetlands. In this case, my memory is that Sea Island Acquisition applied for a permit to fill 0.49 acres to construct this building. So they tailored their application to meet the threshold quantities available under Nationwide 39. And the Corps conducted its analysis under the nationwide permitting purview and issued the permit, having determined that the benefits of constructing the building outweighed the environmental costs of the limited wetlands impacts. And I think it's note there at the bottom, there's no nationwide permit that would allow for filling wetlands with sod or landscaping. And that's important, we think, in what we stated in our briefs and in our complaint. It's important because since no building was ever constructed, they could not have used a nationwide permit to pursue what ultimately appeared to be their goal from the beginning and still is in place now, which is landscaping. Part of the permitting process involves a jurisdictional determination. But the first thing the Corps of Engineers is supposed to do is determine whether they have jurisdiction over the area that is proposed to be impacted. And that has become an increasingly complicated process because for the last decade and a half, the rules have continued to change. Lawsuits and litigation has continued to sort of bubble up toward the Supreme Court and through different circuit courts. And as it stands now, some states are applying certain rules. Some states are applying different rules. Different court districts within states themselves have different evaluation procedures that they use to make jurisdictional determinations. And ultimately, cases like Sackett and the cases before it have been couched in terms of these jurisdictional determinations, and really, I think in a bigger picture and why this has become such a politicized process is that these are policy issues about the extent and reach of the federal government, not just what the Corps should and shouldn't regulate, but the power of the federal government to reach into certain areas, and as opposed to the power of states to regulate themselves. And so for that reason, the Obama administration created a new rule, which was then later changed by the Trump administration, which was then changed by the Biden administration, which was then changed by Trump again. And at every step along the way, litigation happens, and in many cases, these rules get stayed or sometimes implemented in certain states. So it has created kind of a mess for the regulatory community or the regulated community to understand what the rules are and what they're allowed to do and not do. And so back to the slide, I mean, what we've tried to point out here is that there are a couple different ways to go about this jurisdictional determination process. A landowner can seek a full, formal, approved jurisdictional determination, which involves applying to the Corps of Engineers, having the Corps of Engineers visit the site, having, sort of the full body cavity inspection to evaluate whether the jurisdictional water or the water that's proposed to be affected is the jurisdictional water of the United States. There's also a separate process, which is really important as it turns out to what later became the substance of our Supreme Court appeal. There's a separate process that an applicant can proceed under called a preliminary jurisdictional determination that allows them sort of a shortcut, an abbreviated process where they describe certain facts and features of the proposed project area and accept, sort of sign on the dotted line saying that this is a jurisdictional wetland, we agree that it's jurisdictional, and there's no need for you to go through your formal approved jurisdictional process to confirm that. So in this case, Sea Island chose to accept or apply for and propose a preliminary jurisdictional determination, and in doing so, they have to sign a waiver that says, in connection with their decision to abbreviate the process and the benefits that are obtained from that they'll not contest the jurisdictional status of the wetland at a later date in any federal court. And the language from that waiver appears at the bottom. We believed it was plain on its face, and we're obviously surprised and a little disappointed in the way that things turned out, but the words seem clear. Accepting a permit authorization constitute agreement that all wetlands and other water bodies on the site affected in any way by that activity are jurisdictional waters of the United States, and precludes any challenge to such action in any federal court. We thought that language was extremely broad and was intended to read that way and operate that way. And as it turns out, that's not the result that was reached. But and Laura, feel free to jump in at any point.
Next slide, Rachel. So this drawing just is, pictures worth 1,000 words. This is an actual drawing that Sea Island provided to the Corps in 2013 when they were applying for nationwide permit 39, which again is only applicable to construction of a commercial office building. So they provided this information representing that they were going to fill 0.49 acres of wetlands as a parking lot for the building that's shown in the drawing. So next slide on that, Rachel. Another drawing provided to the Corps in 2013 shows, in green, the highlighted area is the wetland area. And one thing I wanted to point out here is that the wetland, and this will come up in our subsequent discussions. There's a road that connects Sea Island Road, which is at the top of the drawing there. There are pipes located underneath that road that, in our minds, serve as that continuous surface connection. In other words, water drains from the wetland into the tidal marsh that's located on the left side of the picture, and vice versa. There's influx of tidal water that's coming from the marsh and its connection to Dunbar Creek. And so in our mind, that meets the continuous surface connection test that, of course, was not around in 2013 when we first filed the suit, and came later in Sackett. But that's one of the drawings, and that point we illustrated to the court.
To Laura's point on the continuous surface connection issue, which is something that we talked about at oral argument with the 11th Circuit and was discussed in our briefs. That was not the standard when we filed our petition or our initial complaint. The standard was a significant nexus test under prior Clean Water Act jurisprudence. And at the time that we decided to pursue this matter, and when the court requested additional briefing, we revisited our expert reports, and we concluded that our experts had used in almost exactly the same magic terms that wound up being the standard that was applied in the Sackett case. And so we believed strongly that we had, even though that standard didn't exist at the time, our experts had used words that meant almost specifically to the word that there was a continuous surface connection between the salt marsh and this wetland. And Laura, you can correct me if I'm wrong, but I think the name of the road under which those pipes traveled is Salt Marsh Road.
That's right. Ironically, no, Salt Marsh Road. And you can't see the pipes in this picture, but they're underground. They
would run sort of in parallel with Sea Island Road, which is at the top, and would connect those wetlands back toward the salt marsh. So Laura, I interrupted you.
No, it's okay. And let's, for time's sake, we'll quickly, Rachel, go through the next couple of slides, which show some aerial photographs, so you can further understand the area that we're talking about. So this is Google Earth as of 2012. You can see the area to the northeast of where the Sea Island Inn building is vegetated, a wooded wetland area. If you move to 2013, on the next slide, Rachel, that's right after the clearing impacts took place and cleared and removed the vegetation from that wetland. And keep in mind that was under the Nationwide Permit 39 that was issued, which authorized clearing of those wetlands in order to construct a commercial office building. And then fast forward, I think the next one is 10 years later in 2024. You can see that there's no commercial office building built at that site, and that just continues to be a wetland that was filled to put down sod. There's no economic benefit like the permit requires. If a commercial building was there, presumably it would employ people and contribute to the community in other ways. But this was just filled in and sodded and left sodded 10 years later. So there doesn't appear to be an intent to build the commercial building. And I think there might be one more. No, okay. Let's talk about the case that was filed then back in April 17th, 2019. And when the case was first filed, things take a little bit of time in the district court for some preliminary motions. And the first big decision we had from the court was an order that came on January 29th, 2021, where the case was dismissed for lack of Article 3 standing. Now, Article 3 standing is an attorney word, and we know a lot of folks are on this webinar. So I just wanted to explain very briefly what Article 3 standing is. It refers to Article 3 of the United States Constitution. And in order to have a case that can be filed in court, a plaintiff must show that they've suffered an injury in fact. That's a term of art that's used in the court. And that injury in fact must be concrete and particular to the plaintiff, not a hypothetical situation or a general situation that might apply to anybody, but specific to the plaintiff. It's got to be traceable, and we say fairly traceable, to the action of the defendant, in this case, Sea Island's filling in of the wetland, and then redressable by a favorable decision of the court. And what the district court said when they dismissed us was that the pleadings of the plaintiffs in this case were not sufficient to show an injury in fact that was concrete and particular to the defendants. And there's some language on the slide that comes directly from an affidavit that was filed in the initial pleadings of this case, where a statement was made. I derived aesthetic pleasure from the subject wetlands. and the similar habitats that it provided. The subject wetlands was aesthetically pleasing, and it was a natural resource, and it was replaced by the unnatural grassed areas that we showed on the prior slide. In particular, the statement, "I drive over the creek," on Sea Island Road, which is the primary thoroughfare to the mainland. Since then, there's been a significant difference in the water clarity in Dunbar Creek. So that aesthetic interest that was presented to the court in the initial filings, the district court said that was not sufficient to establish an injury in fact. In other words, there was not Article 3 standing at this point.
Before we do, and no, it's probably appropriate to put the next slide up. I'll just say that from a litigation perspective, it's really common for plaintiffs to face an Article 3 standing challenge in citizen suit cases. And we had anticipated that this would be an issue because the wetland, the subject wetland, it turned out to be, what the entire case was about, was located on private property. It was less than half an acre of wetland on private property that, unlike a lot of these cases that deal with public property or other, very large park areas or other circumstances where people can actually use, physically touch and enjoy the resource. This was a circumstance where we understood that we would be challenged on standing because the only way that we could demonstrate standing was probably through aesthetic purposes. And that's what the quote that Laura read from Ms. Fraser's affidavit was that she drove down a street and was able to, and had demonstrated a longstanding interest in and experience and more than just a statement. She demonstrated a longstanding sort of proven interest in working toward the protection of resources like this and using and enjoying them. While she had no ability to physically enjoy this resource, there was clearly, her pattern and history of deriving aesthetic pleasure from the resource. And so I'll let Laura talk about the first appeal to the 11th Circuit in the case.
All right, so the first appeal, we had a very good outcome, and actually an outcome that is significant to environmental plaintiffs and environmental groups, and has been cited widely already and will be a positive in future Clean Water Act citizen suits, and also citizen suits under other environmental statutes. But at the top of the slide is a quote from the 11th Circuit's decision in our first appeal, which said a plaintiff suffers an aesthetic injury when she uses the affected area and is a person for whom the aesthetic value of the area will be lessened by the challenged activity. And so because Ms. Fraser's aesthetic injury and others who are in this community who are viewing the wetland, but because her injury was affected by the activity that we alleged violated the Clean Water Act, then the 11th Circuit reversed the decision of the district court, and so that we did have Article 3 standing. We had a concrete and particularized injury, and that we could continue our case. And at the bottom of the slide, we've got some statistics about this particular decision of the 11th Circuit, and that it's been cited in 30 or so judicial decisions since this opinion was issued in 2022. We expect it to continue to be used, and in particular, we found a couple of environmental groups. The court cited this opinion when it found that other environmental groups had Article 3 standing to pursue their Clean Water Act citizen suits.
Just reflecting back on that, the case law was messy on standing, and it seemed like every case that you read, could have been decided one way or the other, and it felt like there were some subjective standards being applied. And so we understood that it would be a challenge, but we felt like there was enough case law out there dealing with aesthetics and potentially even on private property that there was an argument to be made. The trial court did not agree with us. The 11th Circuit granted our appeal, obviously, and granted our request for oral argument, which surprised us a little. And then at oral argument, the 11th Circuit panel was was pretty decisive about how they felt about this. And they felt like the case law wasn't that messy and wasn't as messy as maybe the litigants thought it was. And the 11th Circuit panel was very clear at oral argument about how they felt on this issue. And we didn't just feel really good after leaving that argument. We felt like we had succeeded. And ultimately, that's how it turned out. And I think it's hard to overstate the importance of this from the perspective of organizations, non-governmental organizations. The reason this case has been cited so many times among really a whole slew of standing cases is because this case drew a really clear, bold line that plaintiffs can use to establish standing, whereas prior cases sort of seemed a little ambiguous. And so I think you'll see this case continue to be cited for that premise, because that 11th Circuit panel was really clear, and the opinion was very clear about this type of aesthetic injury is redressable in court.
And you don't have to have access to that property. Just being able to view the property is enough. So, do you want to talk about Sackett? Or do you want me to?
Yeah, well, I think everybody's talking about Sackett. Everybody in the legal community. In 2023, the Supreme Court issued its opinion in Sackett, which is sort of but it is a landmark opinion that we believed would change the landscape of how wetlands would be regulated in the United States. It has been a little slower to take effect than we thought, maybe, but it is happening. And what Sackett significantly curtailed federal jurisdiction over wetlands. And since the ruling in Sackett, there have been proposed rulemakings and efforts by states and efforts by the federal government to develop a rule to put meat on the bones. But essentially what Sackett decided was that in order for a water to be subject to federal jurisdiction, the water must meet both parts of the test. It must be relatively permanent, which is adjacent to a relatively permanent water, and have a continuous surface connection to that water. And this is a big departure from the prior test. The prior test was a significant nexus test, which meant that if your wetland was connected to something that was connected to something that was connected to something, where some nexus could be drawn between an impact at one end of the spectrum and a resource at the other end of the spectrum, or what was clearly a federal resource at the other end of the spectrum, then federal jurisdiction would apply. And I think the court in the Sackett ruling really tried to, and I thought used some pretty clear language to try and restrict the scope of federal jurisdiction to waters that were adjacent to relatively permanent waters and have a continuous surface connection to those what was considered traditionally navigable waters.
That phrase continuous surface connection, though, was not specifically defined by the Sackett court. EPA and the Corps are trying to define that term in some regulatory rulemaking that's coming up. But in our case, it was a question: do the pipes that connect that have tidal influence, and we believe is a continuous surface connection that has water in it some of the time, but perhaps not all the time, qualifies as a continuous surface connection, and that will.
Further to that point, I mean, this is a subsurface pipe,
right,
that contained surface water, and we even had discussion with this with the panel on oral argument. Is that a continuous surface connection if it's in a pipe that's under the ground? And while I think the Supreme Court in Sackett tried to be clear, it's just the nature of the beast with the English language. There are a lot of different interpretations of what continuous surface connection means. And the court went further than that even. And the next bullet point on this slide shows, I guess the point I'm trying to make is the court also stated that in order to be jurisdictional, the wetland must directly abut the traditionally navigable water, such that there is no clear boundary between them, and that traditionally navigable water. And such that the wetland and the jurisdictional water are, as a practical matter, indistinguishable. And that is a very, very long way from a significant nexus. And I think and as we'll talk about it later, there's some discussion and some court treatment of this issue now of what indistinguishable means, and how that affects federal jurisdiction in this case.
Yeah, so the second dismissal by the district court was, after Sackett, after we had our very positive outcome for the first appeal that found we had Article 3 standing. The district court then brought Sackett into the equation, and they looked at what we said in the initial papers that we filed to the court, 4 or 5 years before Sackett. And that district court once again dismissed us, and they found that the wetland was not part of the waters of the United States after Sackett. The other part of that argument was that, if you'll recall the waiver that we talked about in the beginning of this presentation, where Sea Island did not do a full approved jurisdictional determination. They relied on a preliminary jurisdictional determination and a waiver. And in that case, Sea Island said and agreed, and this is the same language you've seen before, but I am repeating it for emphasis, that by accepting that permit, they're in agreement that wetland, the subject wetland on Sea Island's property, was a jurisdictional water of the United States, and they agreed that they wouldn't challenge that jurisdiction in any federal court. But Sea Island did just that, and the district court allowed it, and said that Sea Island's right to contest the jurisdictional status at this point after Sackett was an argument that could not be waived. And so, given that, the court then looked at specifically what we said in our pleadings, again, prior to Sackett, and dismissed us again, saying that wetland was not a water of the United States.
It was hard for us at first to understand how the court could read this broad language and decide that a citizen suit could not sustain itself, could not be maintained where a waiver like this was in place. We struggled with it. What the court emphasized was that perhaps the federal government could challenge a case like this if a waiver had been signed, but that as strangers to the contract between the federal government and Sea Island, the contract being the permit and the waiver that they signed, as strangers to the contract, that we would not be permitted to challenge it. We did not have any sort of third-party beneficiary rights under the contract, and therefore we didn't have any basis to challenge the failure to meet the terms of that waiver. So I think one way to view this is that these waivers could still be enforced by the government. In this case, the Corps of Engineers was clear that it was not going to step in and assert any sort of violation or pursue any litigation on this particular violation that we alleged. And so it doesn't help us in this case, but the ruling, at least with respect to this waiver issue, is limited to citizen suits and their rights or citizens as rights as private attorney generals to pursue claims under the Clean Water Act citizen suit provisions. So it is limited in that way, but still frustrating to us. And we felt like at this point we had a decision to make, whether to appeal to the Supreme Court at all, and then if so, what issues we felt like might be appetizing for the court. It was within just a couple of years of the ruling on Sackett, we, rightly or wrongly, we believed that the court probably would not have an appetite to see another challenge on the Sackett issue. We felt like the pipe under Salt Marsh Road contained water that transacted between the wetland at issue and the salt marsh, which was clearly a jurisdictional water. We felt like our expert reports used most, if not all, of the magic terms and buzz phrases. And while we believe that the Supreme Court would just be very unlikely to take that up, and their tendency is to let circuit courts sort of hash this out and see if they can figure it out among themselves before, and allow years to pass, decades to pass, before they would take up another case like this. maybe we were wrong about that, but that was our decision that probably our better approach to a Supreme Court petition would be the waiver issue. And we felt like the scope and breadth and plain language of the waiver was so clear and such an easy way to determine, to rule in our favor, essentially, that and it has such a broad effect. I mean, one of the points in this slide is that the Corps report's making 50,000 or so jurisdictional determinations each year, and we had a lot of trouble finding that number. We had to do a lot of public record requests and do some math, and the Corps their record keeping on this issue is less than perfect, but after doing some gymnastics, we figured out that there are some 50,000 jurisdictional determinations each year. Most of them are preliminary jurisdictions. And so this waiver is signed in tens of thousands of cases every single year. And every single year, presumably citizens are precluded from pursuing citizen suit claims under what we believed was intended to be a very broad power sort of provided and issued to citizens to pursue Clean Water Act citizen suit claims. And so we made the best case we could in that Supreme Court petition on this waiver issue because we felt like it was a strong argument, the language was clear, and we could demonstrate that this was a big deal, that this was had a big impact to a lot of people in a lot of parts of the country.
Yeah. And John, to your point, even though the waiver is used so frequently, we couldn't find a case where the waiver had been denied and this had been challenged.
Another reason we felt like there's sort of some unfairness associated with this is that once a preliminary jurisdiction is issued and an application is made and a permit is approved and work is done, it's very difficult to put Humpty Dumpty back together again. 10 years later, when we tried to look back and see, what the hydrology looked like, what the vegetation looks like, what the water circulation patterns look like, it's very difficult to recreate that and understand perform a jurisdictional determination a decade later when the world doesn't look the same. And aerial photography doesn't show everything maybe that you need to analyze to understand the issue. And so we pushed that argument hard, and we pushed it at the 11th Circuit, we pushed it in our briefing, we pushed it at oral argument, and we felt like this is bad policy to allow people to gain the benefits of an expedited permit process, to destroy a resource, and then to force a plaintiff to prove something that in many cases can't be proved again a decade later.
Yeah, so, and that goes back to the importance of wetlands and the importance of wetlands especially to coastal Georgia, and something that I know is believed by the parties that joined us in submitting an amicus brief to the court. And for those that don't know, this amicus brief is a friend of court brief. It's submitted by parties who want to, in this case, they wanted to support our petition and ask the Supreme Court to grant our petition. Even though it wasn't ultimately granted, we had support from some local associations in Georgia, and I think we've got at least, I think, one member of a group. And Rachel, if you want to introduce the groups that were involved in the brief and let them say a few words if they'd like to at this point.
So we had 3 organizations support the petition to the Supreme Court through the amicus. Georgia Conservation Voters, Science for Georgia, and Ogeechee Riverkeeper. And we do have one of our amici organizations with us today, and we'll very briefly hear from Ben Kirsch, who's the legal director with Ogeechee Riverkeeper. Thanks, Ben.
Yeah, thank you. And we were very excited to join this case as well. Just briefly, Ogeechee Riverkeeper, we're a nonprofit organization dealing with anything that touches on the Ogeechee River Basin. So our mission is to protect, preserve, and improve the water quality of our 5,500 square mile basin. And we've been talking about wetlands. Wetlands are being filled at an alarming rate in coastal Georgia, and they need all the protection they could get. And while this lawsuit focused on just a specific bad actor and a limited amount of wetlands and not even within our basin, it's any rollback of the Clean Water Act that's really a threat to wetlands, to the region, and to the country as a whole. So we were really honored to add our voice here and add it to the fight and continue our fight and work with our partners throughout coastal Georgia and the country to protect these vital and rapidly disappearing resources. So thanks for the opportunity for us to join and for us to talk here today.
Well, thank you, Ben, and thanks to the other amici who participated in this case. And not having a background in Supreme Court practice, what we learned was that the participation of non-governmental organizations like Ben's and like the others who are involved as amici here is critical to help get the court's attention on issues like this. And so I would encourage whenever, if there are people who are in attendance today, if your group has an interest in an issue and you see a case, there are pro bono resources out there from a legal standpoint so that you may not have to foot the entire bill or any of the bill in some cases to join as amici. And, if the subject at issue in the case is of interest to your organization, I would encourage you to contact people who might be able to help you find those resources that may be available to you to participate in the process and have your voice heard, because every additional amici that signs on to a case, just is one more voice that can help try to get attention at the level that you need to have your issues heard and your voice heard at the Supreme Court. We knew early on that this would be an uphill battle at the Supreme Court and that our chances were low. I had overestimated our chances and just how low the chances are, but what the slide here reflects is that the Supreme Court now accepts less than 1% of the cases in which review is sought. And we knew that. We understood that the odds were low, but I think it's important to understand that the process is important even if the outcome isn't always what you hope for. And it did achieve certain purposes, not to mention the standing ruling that we already discussed, which is critically important, and I think in retrospect might be the most important aspect that this case generates for future Clean Water Act jurisprudence. But this also sort of tips the court off that this issue is out there. And as Laura mentioned, we had not seen any litigation over this waiver issue. And so in some ways, we thought that the novel nature of the issue might help. And in some ways, we knew that it might hurt because the bell hadn't been rung loudly enough or long enough for the Supreme Court to hear it. But with our case having been filed, raising the issue, it puts the Supreme Court on notice and frankly, the Corps of Engineers and the regulated community on notice that it's an issue and it could be litigated again in the future. And the more that these things come back to the Supreme Court, the more likely they are to actually take a petition and treat an issue. In this case, we felt like citizens having the right to participate in the process under the Clean Water Act citizen suit and being empowered as attorneys general under the law is a critical component, and Congress thought so, was a critical component of a properly functioning and workable Clean Water Act that achieves its purposes. And that's an important enough policy. And the citizen suit language itself in the statute is broad enough and was intended to be broad enough that it could help the government do sometimes what the government is not all that good at. And so we felt like raising the alarm that this is a threat to citizen suits under the Clean Water Act is really important, and it could help pave the way for other discussions and fights about this, and it could be in other cases or through the administrative process, or even in Congress. If enough momentum is generated, then maybe this issue can be fixed with another branch of government rather than the judicial branch.
And Johnny, that's important. We have some more slides on the rulemaking that's coming in the wake of Sackett. I don't know if we're going to be able to go through those in any detail because I do want to leave time for some reflections from others and any questions that have been sent in. But there was a new rule defining waters of the United States after Sackett that was released last year in November. The public comment period for that rule was open until January. That comment period has been closed, and I could talk to you for an hour about the content of that new rule, but I'll just say one thing. That rule makes an attempt to define continuous surface connection, which is the phrase that we said the Supreme Court in Sackett did not define it. And it, basically said that continuous surface connection has to have surface water, at least during the wet season, and is abutting. So not further than just adjacent to, it's actually got to touch another jurisdictional water. Our prediction is once that rule is finalized, the final rule will be published probably later this year. There'll be litigation over that final rule, but arguably, and especially from the environmentalist perspective, this rule goes further and requires even more, and is stricter than even the decision in the Sackett case. So we'll need groups to keep their eye on that and look at that and be involved.
Yeah, that process deserves participation too. I do believe, further to the point we made in the last slide, that participation in these judicial processes are critical because what the Supreme Court says is the law. What the executive branch says is the law until the Supreme Court says it's not.
That's right.
And other courts say it's not. One last point that we mentioned earlier, and then Rachel, I'll turn it back to you, is there is a case pending in actually before the Supreme Court in which there's going to be some effort to drive a little bit more clarity into what it means for a wetland to be indistinguishable from a traditionally navigable water. So I think we don't know for sure, but the court may have been willing to take up a real Sackett-based issue more quickly than we had thought. And it would be good for, I think, everybody in the regulated community to get a little bit more clarity on that.